notice of the records, files, and proceedings in 1 CPC-25-373. The court has reviewed the motion for new trial filed by the defense on May 15th, along with the state's opposition filed on July 1st, and defendant's reply filed on July 22nd. Before getting to the motion itself, counsel, is there anything we should take up preliminarily? Mr. Garner.
Yes, Your Honor. From the state, given the court has reviewed the filings, I think all parties are aware that HRE 606B is heavily implicated in this hearing. As we all know, this is an evidentiary hearing. I would like the court to either make a ruling or take argument about the scope of HRE 606B with regards to the proposed evidence in this case before any witnesses testify if they are here, so that essentially we don't open that door to jurors talking about their mindset as they were deliberating. The rule is very hard and fast in the state's mind, and once you start the testimony about that, you've basically blown the barn doors wide open. So that's what I'd like to address before we call witnesses.
Mr. Otake.
Thank you, Your Honor. Our plan today was simply to call the prosecutor investigator just to confirm a couple of things, and none of which would dive into the jurors' mental processes or deliberative process, but just to confirm a few factual things. After that, we're not intending to call any jurors. We will be relying upon the recordings and the affidavit we submitted, and I think at that point we can have the 606 discussion. So I don't see why we would need to do that before we call the investigator, just to quickly establish a couple of things. But
So defense at this point in time doesn't contemplate calling any jurors?
well, and I will.
At least at this point in time.
Not at this point in time. And, but after further, we're gonna have a discussion this morning, I'm sure, about that, but that's not the intention at this point in time.
How about you, Mr. Garner? Does the state intend to call any jurors at this point in time?
No, Your Honor. The only witness the state has present is Erwin Kili'ipuleole, the investigator from our office. Your Honor, this is, as I mentioned, an evidentiary hearing. The exhibits that were attached to defendant's motion do not automatically enter into evidence. They are required, foundations has to be laid, they have to be authenticated. So without any of that, frankly, Your Honor, I'm wondering what evidence there's going to be presented at all in this hearing.
So I'd like to give the opportunity to Mr. Otake to present whatever evidence he wants in support of the motion. I understand that the application of Rule 606B is going to be of significant contention today, but if we're not calling any jurors, I think I'm comfortable waiting to actually flush out the details of 606B, especially for not having any jurors here today.
Well, I do have an objection to the court admitting and considering the attachments as they have not been authenticated or any foundation laid.
I understand. Anything else we should take up preliminarily?
Just that the public prosecutor's role is to seek justice, not conviction. So if he wants to make a hyper-technical argument to block the court from considering clear statements made by the foreperson as you deal with this important motion, I guess that's his prerogative. But I think we can move forward as we planned, and if the court has further questions or if we need to take that issue up further, we can as we progress here this morning.
Okay. Counsel, I appreciate your thoughts. With that in mind, any other preliminary matters we should take up?
Not preliminary, Your Honor. Thank you.
Nothing else from the state.
Then, Mr. Otake, it's the defendant's motion. It appears that you have at least one witness you wish to present in support of the motion.
We do, and that would be the prosecutor's investigator, Mr. Kili'ipuleole. But I think a little background on that is important, Your Honor. As you know, Your Honor set pretty detailed scheduling order in terms of briefing and whatnot. And so we filed our motion on May 15th, 2026. We included in there an affidavit from the foreperson. And of course, that was with Your Honor's explicit permission that we could speak to the jurors further. following that, it appears, well, we now know that the prosecutor's investigator went out and interviewed the foreperson who submitted the affidavit on June 5th, 2026. Then their opposition was filed on July 1st, 2026, which would have been, 26 days later. And at the time they filed their opposition, they referenced that the investigator tried to talk to the foreperson, but they said something about how 26 days later, the investigator's report was not concluded, and therefore they did not include any reference to what exactly transpired in their opposition, even though the interview was 25 days earlier. Then on the next day, July 2nd, 26 days later, the prosecutor's investigator did complete their report day after the opposition was due, and then that report was then later turned over to us, I believe, if I'm not mistaken, after our reply was due. So that's just the background as to why we have to call him today. Had the report been generated, less than 25 days after the interview and given to us prior to our reply, we could have included this in the reply, but due to the timing of it, that's why we have to proceed this way. But it's a relatively short questioning, Your Honor, just to establish a couple of things. So it won't take long.
I'm not going to preclude your ability to present evidence, Mr. Otake.
No, I understand. I'm just letting you know the context of why we have to do it. Thank you. So with that being said, we call Mr. Erwin Keli'i Pule'ole to the stand.
You do solemnly swear affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can have a seat. Counsel, I'm sorry, I should have mentioned this earlier. When you're examining witnesses and when you're addressing the court, because we don't have a live we ask that you make sure that you are projecting into a microphone, meaning that microphone is in front of you. You can be at counsel's table or at the podium, your choice.
Thank
Please
you, Your Honor.
proceed.
Good morning, sir. Could you please state your full name for the record?
Yes, Erwin Keli'i Pule'ole.
Sir, are you an investigator with the Honolulu City and County Prosecutor's Office?
Yes, sir.
How long have you held that position?
4 years.
I want to ask you about what appears to be an assignment you were given related to this case. At some point, were you asked to try to locate and interview the foreperson from the jury in this case?
Yes, sir.
Do you recall when you were asked to do that?
I believe it was June 1st.
June 1st.
Yes.
Are you aware that our motion was filed on May 15th that included an affidavit from the foreperson? Are you aware of that?
I'm not aware of the date it was filed.
Okay, but you're aware that there was an affidavit attached to our motion from the foreperson, yes?
Yes, sir.
And June 1st, you received the assignment. Were you eventually able to interview the foreperson or attempt to interview and made contact with the foreperson on June 5th, 2026?
Yes, sir.
Now, is it typically your practice to submit and document a report shortly after you interview somebody?
To document, yes.
Okay. Your report in this case is dated July 2nd, 2026, correct?
Sorry. Yes, correct.
And it's essentially roughly 2 pages long, correct?
Yes, sir.
It describes the history of you're trying to contact the foreperson, correct?
Yes, sir.
And then also includes some of the things that the the foreperson said to you, yes?
Yes, sir.
One of the things that the foreperson said to you when you interviewed her is that everything on the paper that she signed for the defense counsel affidavit and everything that she said to the media was true. She told you that, yes?
Yes, sir.
Your Honor, hearsay.
Sustained.
Well, can we approach?
Sure, come on up.
Counsel, thank you for the benefit of your thoughts.
Court
Will
overrule the objection. Allow Mr. Otake to continue on his examination. And the court has determined that would be consider what is and is not permissible and it is with final rules. So as such, latitude can be given. So Otake.
Thank you, Your Honor. And sorry, Mr. Kennedy Pule, that was the last question I had. I just want to ask it again. When you did have a chance to make contact with the foreperson, one of the things that she confirmed to you or said to you is that the paper she signed, affidavit she signed, and what was contained in it and everything that she said to the media, she confirmed with you that that was all true, correct?
Yes, sir.
Okay. Excuse me?
Yes, sir.
Okay, thank you. No further questions.
Any cross-examination?
Question number two, please. Mr. Khalid, now, you were originally assigned to try and speak with Ms. Atkins on June 1st, 2026, is that right?
Yes.
How did you initially make contact with her?
I attempted to call. I got her on the phone on June 1st. She said I explained to her the whole situation of me trying to set up an interview with her. She said she'll have to talk to her supervisor and call me back by the next day to
Couple
confirm.
clarifying questions. When you said you called her on the phone, what phone did you call her on?
I called the district court's bailiff office
So
phone
is
number.
this a personal phone or a business phone or what?
Work phone, I believe.
So you didn't call like her home phone number or cell phone?
No, sir.
And when you just said you were talking to her to set up an interview, was your assignment to actually interview her yourself, or was it to set up a time for her to sit down for an interview?
It was to set up a time we could interview.
So on that week of June 1st through June 5th, you weren't actually trying to get a statement from Ms. Atkins, is that fair?
Yeah, no, sir.
And when you called her initially on June 1st, you were able to speak to somebody who identified themselves as Makalapua Atkins on the phone, is that right?
Yes, sir.
And during that call, she suggested Friday, June 5th as a date to potentially have that sit-down interview, is that right?
Yes, sir.
But she also stated that she wanted to talk to her supervisor beforehand.
Yes, sir.
And then she told you that she would call you back when she confirmed that she was going to be sit-down. Is that right?
Yes, yeah.
Did she ever call you back?
No, no, sir.
Did you ever try to call her back?
I attempted to call twice.
And did you, again, try to continue to call the bailiff's office at the Honolulu District Court?
Yes.
So again, you're not going after her cell phone or her home phone or anything like that?
No, sir.
So when you weren't able to contact her by phone again, did you actually make contact with Ms. Atkins in person on June 5th?
Yes, sir.
Can you explain how that happened?
So I walked over to District Court. Our office is right across the street where I work. I went to go look for Miss Atkins or her supervisor, who was identified as Jerry through these phone calls. I was able to locate her supervisor, Jerry, and he escorted me to speak with Miss Atkins.
And where did you end up meeting with Ms. Atkins?
I believe it was on the 3rd floor in the hallway area by the elevators.
Was anybody else present as you met with Ms. Atkins at that time?
Yes, the supervisor, Jerry.
And again, the purpose of this meeting was not to actually interview her on that day, it was to set up a future interview, is that right?
Yes, sir.
Did you explain that that was the purpose to Ms. Atkins?
Yes, sir.
And she responded to you that she didn't want to talk to anybody from the prosecutor's office.
Yes, she didn't feel comfortable.
And she was visibly upset when you talked to her, right?
Yes, sir.
Her demeanor was...
Emotional, crying.
Ms. Atkins also, during that time, told you some things about her statements to the media, right?
Yes.
She told you that she didn't want to talk to the media, isn't that right?
Yes, sir.
She also told you that she was ordered by the judge to speak to the media. Is that correct?
Yes, sir.
She told you that she was ordered by the judge to speak to the media.
Yes, sir.
How many times did she say that?
She said it once, then I asked her again, and she repeated the same answer.
She also told you that she didn't want to be the foreperson, is that right?
Yes.
And she told you that people had been contacting her and her family on social media, is that right?
Yes, sir.
And that people had been showing up at her job.
Yes, sir.
She also told you that she met with the defense in this case, is that right?
Yes, sir.
And that they prepared an affidavit or a declaration for her, correct?
Yes, sir.
At that time,
Hang on. Please, continue.
so at that time on June 5th, were you familiar with the declaration that she had signed?
I wasn't familiar with any details about that declaration.
So you hadn't actually read it yourself?
No, sir.
Now, on June 5th, did you also give Ms. Atkins a date to call you back if she changed her mind and did want to give an interview?
Yes, sir.
Did she ever call you back after that?
No, sir.
Thank you. No further questions. Oh, I'm sorry. I do have.
Go ahead.
I'm sorry. So initially, you completed. Sorry. After June 5th, did you prepare a report?
Yes, sir.
Okay. And that report was submitted on July 2nd. Is that right?
Yes, sir.
When did you draft that report?
July 5th. June 5th, correction. Yeah.
Okay. Were you on leave at any point in June?
Yes, I was.
Were you on island?
No, some part of June, but when I was on leave, I was off island.
Okay.
Yeah.
Approximately from when to when in June were you on leave?
It was, I believe it was June 15th, I left the island. Yeah.
And came back at the end of the month?
I came back at the end of the month.
Thank you for clarifying. No further questions.
Mr. Otake, read it right.
Sir, did you record the interaction you had with the foreperson?
No, sir.
And when you drafted your report, sounds like, what, several days later? Is that right?
I drafted it that day,
On June 2nd?
on June 5th.
On June 5th is when you drafted it.
Yes.
And so you summarized what was said, correct?
Yes, sir.
You did not have a recording of what was said, right?
No, sir.
One of the things you said is that at the outset, the foreperson told you she didn't feel comfortable talking with you, yes?
Yes, sir.
And then you continued to talk with her, yes?
She was continuing to talk with me, yes. Yeah.
No further questions.
Any other questions?
Just to follow up on that last little bit there, Mr. Kaliipulele, these statements that the foreperson made about being ordered to speak to the media or not wanting to speak to the media, did you question her about these things?
She brought it up first, and then I questioned her again about it.
Thank you. No further questions.
Mr. Otake, any other questions?
No, thank you.
Mr. Kuli'ikuli'ole, thank you for being here.
Thank you, Your Honor.
Watch that first step. Mr. Otake, does the defense wish to present any other witnesses at this point in time?
Your Honor, I guess the first, issue or question is based off of what was testified to today, that the prosecutor, investigator confirmed with the foreperson that she confirmed to the prosecutor's office that everything in her affidavit was true and everything she said to the media was true. Based off of that, we would like to admit into evidence her affidavit and all of the exhibits attached to her motion. And the reason, as I discussed at the bench, I think is worth stating here on the record. This has been very uncomfortable for the foreperson, and we have tried our best to proceed in a way that is least uncomfortable for her. She just came here to try and serve. She didn't want to get involved in any of this. Unfortunately, things were said after that prompted us to have to look into this. That being said, we are trying our best to, protect her privacy, to not aggressively, go after her. We never tried to interview her while she was at work in front of her supervisor. We tried to be a little more discreet than that. And as you see, I've been referring to her as a foreperson. I didn't even say where she worked, anything like that. For that reason, as she indicated to the investigator, as you know, this case has generated national attention, and I can tell you she's not the only one getting awful emails. Our firm has gotten countless awful emails because this was allowed to be broadcast nationally. Nevertheless, we're trying to do our job, but also be respectful of a juror. And that's why the issue isn't, did she say these things? We know she did. She told the prosecutor's investigator that she did. It's recorded on the media, so we know she said that. The issue is, does 606 allow you to consider it, and if so, what is the impact of that? So I'd ask the court to accept these things into evidence, and maybe a hyper-technical application of the rules, maybe it's an issue. I would first ask the prosecutors to stipulate that they can come into evidence. I mean, they know she said these things, so I don't know why they'd want to try and block it through a hyper-technical application of the rules that would further make a juror who's just trying to serve be incredibly uncomfortable. And then we can argue about what the import of it is. But so for those reasons, I'm asking the court to accept the affidavit and the exhibits into evidence, and whatever you decide to do with it thereafter is we're going to talk about that. But so I guess that's a long way of saying, when you ask me if I have further evidence, it depends. Further witnesses, it depends on how you rule on this request. Thank you.
Mr. Varner, with respect to the admission of what has been marked for identification and attached to the defendant's motion as exhibits A, B, and C.
I have a bit of a record to make with the rest of each of these. So I'll start with Exhibit A. Exhibit A is a TikTok video that is cut so that the question being asked of the foreperson is removed. There's text overlaid. We don't know, as far as I couldn't find the full version of this interview anywhere after looking for it. It's incomplete. We do believe that, and I'm not being hyper-technical here, Your Honor, the requirement to authenticate evidence, the requirement for foundation is foundational. It's not hyper-technical. This is something that you learn in your first year of law school. That if you want to enter evidence, you need to lay a proper foundation. The evidence needs to be authenticated. So I do have objections to all three of these videos coming in. Exhibit A is especially problematic, being that it's cut. Exhibit B and C do appear to be more full conversations between media representatives and two of the jurors. Exhibit D is as I think I said in my memorandum, a printout or a screenshot of a YouTube video of a comment from the YouTube video. There's no authentication as to who made this statement, no indication of its reliability. It's frankly an anonymous internet comment, so it's not admissible for that reason as well. All of this evidence, and like I said, there is a burden that is on the defense in any motion for new trial. They have to present evidence and make a prima facie case that the new trial is warranted. So ignoring that all, admitting this evidence is very problematic to the state. Lastly, the 606B issue applies very heavily to all three discs of the interviews. They are very clearly the jurors talking about their internal deliberative processes. So this evidence will be barred under 606B as well.
I have a question for you on that point, Mr. Varner. 606B bars the use of the evidence for decision-making purposes. That would be the state's argument, I understand that. But what about the making of the record? If, for example, the court denies the motion and it's appealed, shouldn't the appellate court know what's there, what the court actually kept out?
Well, it's already in the record being attached to the memorandum.
That's the circular way to put it, isn't it? Right?
So yes, it already is in the record, and I'm sure the court has already had a chance to review all the exhibits that were attached to the memorandum, as well as any court would do with anything that's submitted to a memo. So maybe the point is more academic. That being said, it does still bar the admission of these for this hearing. I'll just add that 606 is not a permissive rule, Your Honor. It's, the court may not enter these into evidence.
You know, I understand. So if it's part of the record already, in the end, I mean, the elephant in the room that we're all going to have to discuss is the application of Rule 606. But the exhibits that are attached gives us the basis on which to ground the argument and give us the reason to talk about 606B.
Yes, but I don't entirely agree. One of the cases that I cited in my memorandum was State v. Kim. And the procedural history of that case was there was a similar motion made where a juror had provided an affidavit after the trial, essentially alleging misconduct, some of her own, or alleging reasons for making a decision that were not based on the evidence. In State v. Kim, the trial court, ruling on that motion, denied the request for an evidentiary hearing at all. And that was what was affirmed. So I don't think it's necessary to admit these in this case. Frankly, although we've already had evidence, I don't think it was necessary to have an evidentiary hearing in this case at all.
Understood. Thank you. Mr. Otake, the court takes under advisement the request to what has been marked for identification as defendants exhibits A, B, C, and D. I would like, though, to proceed and hear your thoughts on the application of Rule 606 and the rest of the arguments that are in your motion. For the purposes of argument today, you assume those things have been reviewed by the court, and the court has reviewed them, and they're germane to what we have to decide today.
Thank you, Your Honor. And again, then that makes sense so long as we reserve the right to do what I would hope we'd all want to avoid for the sake of the foreperson. We reserve the right to call her if there's truly going to be some foundational issue to admitting these things.
So no other witnesses at this point in time?
No other witnesses, just argument.
Mr. Garner, did the state wish to present any witnesses at this point in time?
No, Your Honor.
Then, Mr. Park, I'm happy to hear your arguments in support of your motion first.
Thank you, Your Honor. Well, I want to thank the court for your time. One thing, anyone who practices before you for any number of years, we know that for matters like this, of all judges, read everything, prepare, do your own research, and I'm sure you've done that in this case, and we appreciate that. As we know, the jury in this case did come back and return a verdict of attempted extreme mental and emotional disturbance manslaughter. In doing so, they implicitly rejected several things. They rejected that Dr. Konig had a calculated plan to take his wife up on that hike and kill her. They rejected that this was a premeditated attack. And thankfully, what we learned after the verdict is that they apparently rejected that he had an intent to kill his wife at all that day. We've learned that after the verdict. We also learned that the jury did not unanimously agree that he was guilty of attempted murder, something that needed to happen before they could even consider what they ended up on, the extreme mental and emotional disturbance manslaughter. So this motion today presents you with several opportunities, and an opportunity to prevent an injustice by overturning what we've learned is an illegal verdict that did not comport with the law that was given to the jury, an opportunity to right a wrong, and an opportunity to enforce the rule of law in your courtroom. An opportunity to say loud and clear that whether inadvertently or on purpose, whatever, jurors need to follow the law in your courtroom on multiple fronts. I just want to highlight a few things. Like I said, I know you've read it all. Let's start first with I think what is one of the most pivotal issues. Obviously, is what does 606 HRE 606 allow you to consider, and what it prohibits you from considering. And I'll start by pointing out what I hope is obvious to Your Honor and everyone, that Rule 606 doesn't impose a blanket prohibition against anything a juror says post-verdict. And it would have been very easy for the legislature to craft or promulgate a law or a rule that did so. They could have easily said and used language that was altogether restrictive. The court shall not consider any comments or statements made by a juror post-verdict in a challenge of the verdict. It would have been very easy to pass a rule that said that. Instead, what the rules ended up being, it's a limited prohibition on the use of certain things. Not all things, certain things. And it's really important to look at the plain language of Rule 606. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify, and this is the important part, concerning the effect of anything upon the jurors or any other juror's mind or emotions as influencing the juror to assent or to dissent from the verdict, as influencing them, the effect something had on them, the influence something had on them, or concerning the juror's mental processes in connection therewith. Mental processes. Let's break that down. The internal activities of the mind, how someone takes in information, how it affects them, how it makes them feel, why it makes them lean this way or that way. That process of digesting that information and the effect it had on him. Not the result of where they end up, but the process that they underwent mentally to get there. Not where they end up, but why they end up there. And of course, we shouldn't be able to dive into that. You know, if a juror says, I voted guilty, and okay, that's the result. Why did you do that? Well, I didn't think this witness was credible. I don't know, the DNA, you know, or I felt this about that. That's what 606 says we should not get into. And it makes sense because we don't want to second guess. We deliberately leave these decisions to the people, and we don't second guess their good judgment about how they feel about the evidence and how they feel about, you know, we don't want to be critical and say, well, you should have found that witness credible because I think that witness was credible. You know, we don't do that. So that's what, understandably, Rule 606 is meant to prohibit. And we are not asking you to consider any of that at all. We're not asking you to consider the deliberative process, the mental thought process, the decision making, the effect things had on them that ended up with the result. We're not asking you to consider any of that. Or what impact the evidence had on them. You know, we're not getting into, you know, the DNA evidence of how, you know, how the Miss Konig's DNA was all over the rock and things like that. In her hand, you know, we're not getting that. That is what we're prohibited from doing. Not the mental process. We're not asking you to consider any of that. We would agree that 606 would block that. But what the rule allows you to consider, and what we're asking you to look to consider here to prevent injustice and a wrong, is the result. Where every juror ended up, not how they got there. And, you know, so for example, I'm going to get into this later, but, you know, this idea that the statement that, you know, I did not believe he had an intent to kill her. I did not believe he was not guilty. I did not believe he was guilty of attempted murder. Okay, that's not the mental process. That's the result, the objective result. Why did you not think that? You know, if she were to say, well, again, you know, I thought the DNA blew her story out of the water. I thought it was clear there was no premeditated plan. I didn't think the eyewitnesses were overly credible. I thought the cops were exaggerating. That's the mental process that we're not asking you to consider. How they got where they got is different. And the policy behind 606 and striking this balance, it makes a lot of sense. It makes a lot of sense. And from the commentary, it says, Rule 606 commentary, it is meant to strike a proper balance by excluding testimony relating to the internal deliberative process and allowing testimony about objective misconduct and irregularities. So irregularities, if there is objective evidence of irregularities, you must consider it, obviously. Because if not, then we're letting this rule of evidence trump everything we know about the Constitution and due process and the right to a fair trial. And that's what they want you to do here. Use a hyper-technical not even that, a wrong interpretation of a rule to override constitutional rights to a fair trial, to, you know, a unanimous verdict, to due process. And that's why when they drafted this rule, they didn't do that. They struck that balance so that courts, when fortunately, not by anything we did, but on the juror's own voluntary statements to the media after, when it is uncovered that there is an irregularity, as we have here, it allows the court to do something about it. And that's why the rule is written the way it is. HRE, this is from State versus Holbrun, 80 Hawaii 27. HRE 606 does not foreclose judicial inquiry into irregularities affecting verdict integrity. And that's what we're saying here. And you, to interpret the rule the way they're interpreting it, or asking you to interpret it, would render it unconstitutional. We all know that rules can't trump the Constitution. But you don't need to do that. You interpret it the way the plain language says, and it can all work together. Then okay, we apply the rule the way it's meant to be applied, and we apply the Constitution the way the Constitution is meant to be applied. And that's the thing. I guess if when the rule says you cannot consider their mental processes and everything I just mentioned, what do they think that means if it blocks what we're asking you to consider? If it blocks what we're asking you to consider, then that doesn't mean anything. That means you can't consider anything. And so clearly the rule allows you to consider some things. Let's look at then, with that application, what you can consider and should consider. The statements to the media and the declaration of the foreperson. The foreperson's statements to the media, it's all in our motion. I know you read it. The intent to kill is improbable to us. The jury did not believe Dr. Konig intended to kill Ariel Konig, from her affidavit. From her affidavit, I believe Dr. Konig was not guilty of attempted murder. From her affidavit. Sworn statement that that's why we did this, because if there's any doubt she said that, you know, by all means, go interview her, which they did. And I don't know how they went about it that made her uncomfortable to talk to them and didn't record it. And all, but now, you know, in a report that's generated the day after a reply is due, or at least produced well after, you know, but the point is she verified that what was in that affidavit was true. So what does that mean? She has told the prosecutors that what she said, I believe Dr. Konig was not guilty of attempted murder, that's a true statement. Juror number 3, I don't know if he was trying to kill his wife, but he had the capacity to kill his wife. Now here's the thing. Here's the part I frankly don't understand. I'm not so sure what the prosecutor is saying today about this, because the opposition was filed when it was filed, and presumably they meant what they said in their opposition. And let's look at what they said in their opposition about what you can consider. And it's on page 17 of their opposition that was filed by the state. Obviously, we have duties to the court when we file things, that we mean what we say. What evidence, this is their words, what evidence is left after HRE 606B is applied correctly is Exhibit D and statements number 1, 3, and 4 of the foreperson's affidavit. Statements 1, 3, and 4 of the affidavit. Statement 1, I was the foreperson. Statement 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. They are conceding in their opposition filed in this court that you can consider that properly under 606. Statement number 4 from the affidavit. I did not believe that Dr. Konig had an intent to kill his wife during the incident on the Polipuka Trail, and I believe he was not guilty of attempted murder. They concede you can properly consider that under 606. And at first I thought, is that a typo? And then I read what's before and after, and it's clearly not a typo. They believe that the application of 606 precludes, as I've talked about, mental deliberative processes, but doesn't preclude, you know, an objective irregularity, result-oriented kind of comment. So they themselves say you can consider that. So, let's summarize then with what they concede, what can and be properly considered, even by their own admission. Again, the intent to kill is improbable. Did not know if he had an intent to kill. Jury was not unanimous as the intent to kill, and a foreperson believed she believed he was not guilty of attempted murder. So, if you can consider, and because you can't consider all of that, the verdict just cannot stand. It just can't. It's undisputed how your instructions worked and how the law worked. Nobody, I think, is disputing that. There must have been a unanimous agreement to guilty on attempted murder before they could even consider extreme mental emotional distress manslaughter. We all know that. We all know that. We have a juror saying, I didn't believe he was guilty of attempted murder. I didn't believe he had an intent to kill her. So, and if it was not unanimous, the instructions then direct them to go to the assault charges, which did not happen. And, I think we can all agree that even for us lawyers, the instructions are complicated. So I'm not faulting the jurors. I mean, they're human, they're trying their best, but mistakes happen. Misunderstandings happen. And that's not a failure of the system. What's a failure of the system is when we learn about that if we don't take steps to correct it. And that's the way the law works. And if there is an irregularity, there is an irregularity and a fatal flaw in the verdict, because it was not a unanimous verdict, and they did not follow the law the way it was given to them. We talk about how at best, if you look at juror number 3 and what he says, at best that's a non-existent offense of attempted reckless manslaughter from the Stanley case, right? I don't believe he had intent to kill, but maybe what he did had the capacity to. That's reckless manslaughter, and there is no such thing. And I guess I'd ask you to consider this. I mean, I know this isn't exactly what happened, but it's pretty close. Let's say a jury, and it's an important case. Obviously, he was facing life in prison, right? And let's say someone's facing life in prison, and a verdict comes back, and the juries find the defendant guilty of, let's say, murder. Let's say murder first, where he's going to be life without parole, the harshest sentence in our state. And then the foreperson walks out of this courtroom, and then there's cameras there, and the foreperson says, at her own volition and no prompting, well, you know what? Yeah, at the end of it, 6 of us thought he was guilty, 6 of us thought he was not guilty, that they didn't prove it, but we just returned a verdict of guilty. I have a hard time believing that our appellate courts would let that stand. I mean, I would have a hard time believing this court would let that stand. I mean, that would be absurd. And that's essentially what they're asking you to do. Maybe not to that extreme, but pretty close. Pretty close, when we know a juror has said they were not unanimous as to a required element, and she herself has said she didn't believe he was guilty of attempted murder. Meaning, at best, it was 11-1, which that's not what she was saying, but we can't just ignore this. We can't ignore this, and we have an opportunity to fix it. Just to address some of the prosecutor's arguments, we're not invading the power of the jury to act independently. I'm not sure what they mean by that, but we're not. That's the part, the independence of being able to think through things, consider evidence this way, give credibility, weight that way. Yeah, that's their independent right. What they don't have a right to do is not follow the law. That's different than invading their power to act independently. We're not invading jury secrecy. They came out and she said what she said. When you allowed us to talk to her, she said what she said. We never did, nor will we ask her. We didn't ask her, why did how did you end up over there? We're not invading their secrecy. We're not invading their freedom to deliberate. We're not harassing any juror. All of these statements were made freely at their own will. So, I mean, that was the gist of a lot of their opposition, is these policy reasons behind this. We're not violating that. And then again, it's a balance. Yeah, we don't want to inconvenience any juror, make any juror feel uncomfortable, but we also want to get it right and make sure that there was not an illegal verdict. under the Constitution. For these reasons alone, a new trial must be granted. The text messaging, you know, and again, we objected to this being broadcast nationally, but it was allowed. And, you know, then a commenter on one of these live streams commented during deliberations, before the verdict was returned, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. And there's a couple of significant things about that. It says, I've been texting with, which infers a conversation, multiple texts. I've been texting with one of the jurors. It infers an ongoing conversation. The use of the term count 3, they're going for count 3 attempted manslaughter. No one in this courtroom ever referred to anything as a count. Nobody said the lessers is count 2, count 3. Nobody said that. We pointed out how in the statements to the media, one of the jurors did use the term, you know, we went through all of the counts. So one of the jurors in the deliberation room, apparently the term counts was being used, even though we didn't use it in this courtroom. And now this person is using the same term, they're settling in on count 3. What else do we know about that? On the verdict form, although it was not indicated as counts, the third option, which would be, if you wanted to consider them counts, count 3, was extreme mental emotional distress, disturbance, manslaughter. So he said, and presumably, I don't think the verdict form was even publicly accessible at that time. So some guy, wherever he was, and somewhere on the mainland, would have never known that count 3 was extreme mental emotional disturbance, or at least the third option on the verdict form. But he used that term. He didn't just say they're going for attempted manslaughter. He said they're going for count 3 attempted manslaughter, using the same reference to count as a juror did to the media, and picking the number on the verdict form that was emailed. And then lastly, that he correctly predicted the verdict. I mean, that, and there's case law we cited about the import of when somebody correctly predicts something, you know, how it provides an indicia of reliability. So there is indicia of reliability to lead to concern because of that. And I don't believe it is something where we can say, maybe it was just this or maybe it was just that. Remmer versus the United States, the United States Supreme Court case. Private communications with jurors during trial concerning matters before the jury are presumptively prejudicial. Presumptively prejudicial. And the burden rests heavily upon the government to establish harmlessness. That's our United States Supreme Court. Our Supreme Court, 76 Hawaii 172, State versus Voritani. Once a defendant makes a prima facie showing that an improper influence may have affected the jury, prejudice is presumed. Prejudice is presumed. And the state must establish beyond a reasonable doubt that this misconduct did not affect the defendant's substantial rights. From what we've submitted and the arguments we've made and the inference and the indicia of reliability related to count 3, accurately predicting it, the timing of it all, we've made a prima facie showing. Burden shifts to the state to establish beyond a reasonable doubt that it did not happen or did not affect his substantial rights. What did the state do to meet this burden? Nothing. Nothing. It doesn't appear they went and, you know, you just saw they have investigators that work for them full time. Probably many of them. And that's why we put the burden on the government, because they're the ones with the resources. They're law enforcement officers with the right to subpoena things, to get search warrants, to interview witnesses. You know, if they believe there was tampering with a juror, that could be a crime. They could, you know, call people to the grand jury. There's any number of things they can do to meet this heavy burden of trying to show beyond a reasonable doubt that my client's rights were not affected. They did none of that. Call your investigator. Tell us what you did to figure this out, because I would assume you'd want to figure this out. I'd assume you'd want to know, in your role of seeking justice, not just convictions, did this happen? This is concerning. We should look into this. It's not only our burden, but it's our ethical duty to if there was misconduct here, we want to know. What did they do? Nothing. I don't think they wanted to know. I think they were afraid of what they would have learned. So prima facie showing has been made, and they have done nothing to meet their burden to establish beyond a reasonable doubt that this misconduct did not affect my client's rights. Prejudice is presumed. We don't need to show harm. Prejudice is presumed. State versus Furutani. Remner versus United States. Presumptively prejudicial. I come back to what I said earlier, Your Honor. This motion raises important questions about what you are okay with in your courtroom. And I mean that respectfully. Do the jurors have to follow the instructions? The jury instructions, I'm not going to go through all of them, but many of them directly call into question what happened here. You are the judge, this is number 2, page 2, from the instructions. You are the judges of the facts of this case. You will decide the facts, what facts were approved by the evidence. However, you must follow these instructions even if you disagree with them. They're told they have to follow the way the law works. Page 16 of the instructions. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required state of mind, as these instructions specify with respect to each element of the offense. That's the law. They took an oath to uphold that. We now know that that was not a unanimous finding as to the requisite state of mind. We talked about the elements on page 19 and what was required before they could unanimously find guilt on the attempted murder. We talked about how one juror said she didn't believe he was guilty of attempted murder. And then lastly, as to the text messaging issue, one of the last instructions that is given to them on page 43, during your recess from deliberations when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and has been received by the court. It's one of the last instructions you gave them, which raises the question, do jurors need to follow the law in your courtroom? Of course they do. Of course you're not okay with that. It would be an incredible coincidence if somebody, prior to the verdict, used the term count when nobody in this trial used it, and then the jurors used it, that they would know it was the third option on the verdict form, and that they would know and accurately predict the verdict. It would be an incredible coincidence. And we can't, there's too much at stake to just assume that it was some lucky guess. We have established a prima facie showing. There's presumptive prejudice. They could have done any number of things to try and meet the burden to show that it didn't happen. In closing, Your Honor, I'll say this. I'll be the first to admit, this is not ideal. I get it. I don't envy you being in this position. It's not ideal. It's not any of our faults. It's not your fault, surely. You ran a great trial. When I say it's not ideal, I mean this was a long time-consuming trial, resource-consuming trial, energy-consuming trial, and at the end of it all, for this to happen, nobody wants that. It's not ideal. But these things happen. It's a human system. Jurors are human. I'm not faulting them. It's in terms of the application of the law and the way it flows, if you find this, you go here, if you find that, it's confusing. Jurors are human. And again, I'll just say it again. The error that occurred here on the part of the jurors, inadvertently or advertently, it's not a failure of the system or a failure of how you ran this trial. This trial was run, that was not the issue. But allowing
a verdict to stand. Yeah, well, I'm just, but I'm just saying, like logistically, I'm obviously we disagree on certain legal issues. I'm just saying logistically, it was run well, and I'm just saying sometimes these things happen despite our best efforts. But allowing the verdict to stand with clear evidence that it was reached in error, and not taking this opportunity to correct it, that would be a failure, and that would be wrong. So we ask that you do the right thing and grant a new trial. If 606 and the language that is used there, this is exactly the situation. This is why the balance was struck when they drafted that rule, was to be able to take action when there are irregularities like this. And we cannot be dismissive of what was said and what we know about the texting. We can't. We have to err on the side of constitutional rights here, and all, it's all it is. It's just a new trial. We're not it's all it is. So we appreciate your time, and we're asking that you grant our motion.
Mr. Otake, I appreciate the work that you put into the motion as well as the arguments today. If you don't mind indulging me, though, I do just have a couple of questions as is usual in this court. So for the purpose of this discussion, the statements that you've been referencing, let's talk about that. It's an interesting way that was posed to these jurors, okay? And they come back thinking or stating that the defendant didn't intend to kill his wife. I mean, that's the crux of it, right? Did you think the defendant tried to kill his wife? No. And that's where we are today, essentially. If they were to be asked that question, and they would answer yes, the verdict is attempted murder, right? Attempted murder in the second degree.
Assuming all the other elements were met, but yes, as to the state of mind element.
Right. So they're asked the question: do you think the defendant tried to kill his wife? The answer is yes. The verdict is attempted murder in the second degree.
No, then they would consider EMED if they're unanimous.
But that's one way to think about it, right? If they say no, like you're arguing they did, we have some different decision or some different verdict where it can't be attempted murder.
Well, then they would have gone and considered us. They were supposed to go and then consider assault, not EMED, not extreme mental emotional disturbance.
Okay. Appreciate your clarification of that. So next question. The first part of the defendant's motion is predicated on, and your argument is clear here today, that they just misunderstood the instructions or they just didn't follow the instructions.
One or the other. It maybe, and I think it's helpful to say it in the reverse. Given what we know factually, there's no way they could reach that verdict if they followed the instructions.
Okay.
Yeah.
We've had the jury system in this country for 250 years now. I can't imagine other jurors have not made the same mistake. Presuming that. How many cases do we know where we set aside the verdict when the jury says we didn't follow the instructions?
Well, thankfully, in 20 years, this is the first time that has been learned. And I would hope that every time we learn that, we would do something about it. And I'll say what I said that the consequences of getting something right is not a reason to get it wrong. So, if there's a concern that somehow this is going to open up floodgates, number one, I don't think that's a valid concern, because over 100 jury trials I've done, it's the first time I've ever seen anything like this happen. So it's not going to open up the floodgates, number one. So my answer is, anytime we uncovered that a verdict was not unanimous, anytime we uncover that there's irregularities, the court needs to act.
I'm not worried about the floodgates, at least at this point in time, right? But assuming that there's been mistakes on following the instructions before, right, there's no decision that says we set aside the verdict, right?
Well, there's a couple of things I'd say about that. The first is I think, Your Honor, you're assuming it was a mistake or whatever it is, whatever it was.
Well,
right?
that's the argument.
Well, it was either either they ignored it or they didn't follow it, right? Or it was a mistake, okay? I think, well, and we learned about it, so we have to do something about it. And what did we learn? We learned, and you know, the part that respectfully is left out of your questioning is a statement from the affidavit of the foreperson that said, I believe that Dr. Konig was not guilty of attempted murder. Right?
With
So-
objection, that is not what it says.
In the affidavit?
It's not.
Okay, I'll read it.
I'll clarify what I mean by that.
Well, let me read it.
Number four
Let me
is
read
all the
it.
past tense, Your Honor.
Let me read it. If I'm going to be accused of misstating something. Declaration of the foreperson, I'm trying to be respectful to her. Number 4, the statement they said is allowed into evidence. I did not believe that Dr. Konig had an intent to kill his wife during the incident on the Palipuca Trail, and I believe he was not guilty of attempted murder. I think what I just said, she said, was, I believe Dr. Konig was not guilty of attempted murder. So I was just pointing out that that is a statement that was you know, I know you didn't mean to, but the point is we know that, we have that. And I understand, I think I understand your question is does the law tell us what to do with that? I mean, the law tells us that when there's irregularities in a verdict and we learn of the irregularities to a point where it's, you know, in this case affecting his right to a unanimous verdict, which is just fundamental, we have to do something about it. It's fundamental. If there would be, it's one of the most, I think, you know, serious violations of a trial defendant's right that, in terms of these types of challenges. So I would suggest that implicit in the case law, when it talks about being able to use certain things, irregularities, to challenge a verdict, implicit in that is, of course, if we learn that for whatever reason there was, you know, either deliberate or not, that the laws were not followed, with something as so serious as a unanimous verdict and an element, that it would have to lead to the verdict being set aside.
My question was, I understand the argument.
Yeah.
My question was slightly different. Assuming the defendant's argument is right, that they didn't follow the instructions or they ignored it or whatever the case may be, they didn't understand it. This can't be the first jury that has done that, and I can't be the first judge that is tasked with making this unpleasant decision. I'm just wondering what other judges did. We don't know, right?
Well, I mean, I'll say several things about that. I mean, if this ever happened before, where a juror came out on the news and said these things, I mean, if there was a motion and it was granted, there wouldn't be an appellate opinion, right? So I don't know. I mean, maybe it happened, maybe it didn't, but and respectfully, I'm not following why that matters. I mean, even if this is the first time it's being decided, we know what we know, and we should get it right. And I'm not saying that necessarily this is what you're getting at, Your Honor, but if in any way the thought is this is kind of a first impression and it's for the Supreme Court to decide, I disagree. This is.
Well, I'm not fluffing the job. No.
Okay, I know you're not. I just wasn't sure, like when you're saying it, I'm not suggesting that. I'm just saying, you know, I can't tell you if this happened before. I can tell you I've never seen it happen before. So to answer your question, I don't know. I can't tell you if it has or hasn't, but I can say if it did happen and a judge did the right thing and there wasn't an appeal, we wouldn't know. I don't see that as a reason to, you know, if we know what we know, and if we're not going to set aside a verdict after learning it was not unanimous, then I don't know when we would. And so, and anyway,
No, I appreciate
Yeah.
you giving thought and consideration to
Yeah,
these questions.
no, thank you for the question.
Thank you, Mr. Ohtake. Mr. Lerner, state's opposition.
Your Honor, respectfully, I'll take a stab at answering the question you just asked Mr. Otake. There is a large body of case law where similar situations have happened. I have outlined all of these cases in my memorandum. I started with case law in Hawaii. I moved into the Ninth Circuit, and I went to other jurisdictions.
I think in Hawaii it's specifically
I disagree. So, in Hawaii, and if you want to specifically talk about misunderstanding, that would be State v. State v. Laeta.
I'm sorry, Steve, what?
State v. Laeta. It's on page 11 of my memorandum. The proffered affidavit, and just for a bit of background, State v. Laeta was a case involving a issue that came up at a trial where one juror raised an issue where he didn't understand the proceedings in the trial. The juror was voir dired by the trial court judge.
I asked the question of instructions, because that's one of the disputed points of the defendant's arguments is they just didn't follow the instructions. They didn't understand it, or they ignored it. Some combination of those things.
I have Ninth Circuit then for you, Judge Vasquez v. Walker. Cited on page 12 of my memorandum. The court noted the trial judge had read the instructions. The jury had an opportunity to ask questions to clarify, which the jury did in this case as well. The jury knew how to use the communication forms, and in fact did send communications, but did not ask any clarifying questions of the court. The Alaska Supreme Court in Myers v. State. Clearly written instructions may be that clearly written instructions may be misinterpreted by a juror is simply one of the hazards. The misinterpretation is an inquiry into the juror's mental process, and getting into that would violate 606B. So I do think that there has been a lot of case law about these issues, about misunderstanding, mistake, in Hawaii and other states that show that this is not a reason to grant a new trial. Taking a step back, the big issue here is, of course, what started all of this is the statements to the media by two of the jurors. In those statements, the jurors are asked to explain how they reached their verdict in this case. There could not be a more heavy indication that what they're talking about is their mental process in coming to their verdict. Now, one of the exhibits was cut off for the question. The second exhibit, involving the foreperson, she was directly asked, how did you get to manslaughter, or why manslaughter? And that's when she started to explain. So these statements are directly the jurors sharing their mental processes. This is not an objective misconduct. This is not anything other than clearly violating Rule 606B. And I don't know how to put it more clearly than what's actually in front of the court. I do want to point out that defense, in their reply memorandum, also stated that their motion is predicated on this inadmissible evidence. Dr. Konig relies only on the portion of their statements that identified the jury's determination underlying the verdict. It's on page 7. The statements underlying the verdict, the reasons for how they got to the verdict. That's what we're talking about here. All of this comes from those statements. Taking a minute to talk about the application of 606B. I did do a application of 606B in my memorandum, and I did indicate which proffered evidence that would potentially, or that the court could consider under 606B. I want to be clear, though, when I say that statements 3 and 4 can be considered by the court, statement number 4 is all in the past tense, despite being misstated as a present sense statement by the juror, by the foreperson. We don't know when the foreperson believed or didn't believe this, based on the affidavit that the defense prepared for her. It's completely unclear. So I don't have enough information to tell you whether this violates 606B or not, because I don't know if this is in deliberations, if it's sometime before deliberations, if it's a statement for a state of mind she had after deliberations. The information is just not contained in this statement. If the statement is applied as her mental state during deliberations, then it would be inadmissible. But I can't. Then it would be inadmissible.
Okay.
But I can't say that because I can't assign anything further than what is actually written on the paper. And the foreperson is not here to testify as well. Not here to face cross-examination about the circumstances of this. Not here to face cross-examination about who prepared this for her, whether she understood it, whether she had legal representation, what statements were made to her in the process of signing this. All these questions have been unanswered by the defense failing to present this witness, and more. So when I say that the court can consider this, yes, you can. It just has no relevance to the court's determination because there's no time assigned to it. With regards to statement number 3, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. Again, there's no time. There's no time element to what this statement is. And there's also the issue of polling. The purpose of polling is to let jurors who have lingering doubts, that have a doubt later on or that have second thoughts. The purpose of the polling is to let them voice those. It's kind of a speak now or forever hold your peace kind of moment. And that happened in this case. And every juror said they agreed with the verdict as it was read. So, yes, you can consider statement number 3. It just doesn't have any effect because the jurors were polled under oath when they swore that oath to return a verdict according to the law and the evidence. They were polled. They all said they agreed. Overall, what we're asking here, Your Honor, is not to deny this motion on a technicality. And that's the reason that I spent so much of my opposition going through the history of jury trials, the history of jury deliberation, jury secrecy, the history of all this stuff, because it's fundamental to the jury trial system that the jurors don't have their internal deliberative processes examined, brought up, testified to, cross-examined on. All of those things stymie the entire purpose of jury trials. Well, the court sounds somewhat reluctant to consider the effects. There is a chilling effect on future trials if we start opening those doors. There's a massive chilling effect. Any juror in a case against somebody who's potentially very popular publicly, a sports figure, something like that, any juror would be pressured knowing that their verdict could be attacked, that their thought process in reaching their verdict is not secret. It's essentially what we're asking, what you're being asked to do is to break the promise the judiciary made to these jurors. We bring these people in. We ask them to serve, to sit for a month, and they're told that their deliberations are secret. And it is an incredibly, essentially, if you do not believe in secrecy of deliberations, you do not believe in jury trials. As simple as that. So this is not a technicality. This is something where there has been a large body of case law of similar issues in Hawaii, of the exact same issue in other states and the Ninth Circuit. And all of that case law shows that this is inadmissible. Even defense's own admissions that what they're seeking to do is to get into the mental process. I know I know it's stated several times throughout defendants' original motion and their opposition that they don't want to, that that's not what they're trying to do. But in fact, that is what they are looking at. They are looking at the internal deliberative processes of how these jurors came to their verdict. It's not objective. The objective misconduct examples are all throughout my memorandum. You know, when a juror brings in outside evidence to the jury room, objective misconduct. When a juror makes a decision and introduces their own life experiences similar to a victim, objective misconduct. But what all those cases are also very clear on is the court cannot consider the effect of any statement made. Right? So objective misconduct is admissible. That's not what we're talking about here. We're talking about how the jurors got to their decision. We're talking about trying to get into their heads. And that is hugely problematic. And frankly, it is inadmissible for not just policy reasons, but because it's fundamental to the jury trial system in this country. Moving on, getting closer to the end here, Judge, to the YouTube comment. It's an anonymous YouTube comment. The defense is citing the U.S. Supreme Court case, I believe Renner. In Renner, the contact between the outside person and the juror was known. The juror reported it to the court. There was an FBI investigation in that case. There's an FBI report prepared. It's clearly distinguishable from this case where there is no confirmation of juror contact. The specter has been raised, yes, but it's defense's burden to actually make that prima facie case, and they haven't. So we're citing a case with a completely different set of facts and trying to apply it to the same way, and that's not what we have. What we have is an anonymous internet comment. Anytime there's a high publicity case, anytime there's a case that is on the internet, which there are certainly going to be more to come in the future of any jurisdiction. Anytime somebody makes a comment claiming to have inside knowledge or claiming to know something else, anytime that happens, what defense is saying is that should be an automatic granting of a new trial. And that's not true. Lastly, you should consider the actual context of this statement on its face. There's no statement indicating that there was communication, anything other than potentially somebody leaked the verdict. There's no indication of any talk about discussing with the juror how they thought about things, convincing the juror to vote one way or the other. There's none of that. So for that reason as well, there's no prima facie case. So overall, what defense is asking you to do is to get into the juror's mindset of how they ended up at the verdict they ended up. That's what this is all based on. And although they can say it's not what they're looking for, unfortunately, factually, it is. That's how these statements came about. That's how these things were raised. And that's where we're at. And that's why 606B applies. These statements are inadmissible, and the court should deny this motion.
Thank you for your whole presentation, Mr. Varner. Anyone else have questions for you as well? If the court adopts the state's reading of the strict bar on admissibility of juror comments provided in 606B, Hawaii case law does, though, allow the piercing of that shield to determine if there was outside influence on the jury, meaning jurors can be asked whether or not outside influence affected the decision making. 606B doesn't prevent that. It's under case law, right? You're nodding your head. I'll take that as a yes.
Yes, sorry, waiting for the question.
So, I understand the argument about perhaps the defense not making the prima facie case. But there is certain case law that places the duty on the court to further examine and investigate if there is and I wanna use the word in either parentheses or air quotes, credible interference or credible communication with the jury during deliberation. How strict is that bar? What level is that prima facie evidence? Do we not have it here?
To clarify before I answer, Your Honor, are you speaking about, and actually before I get there, I don't believe,
Exhibit D, right? Exhibit D says I had contact with the juror during the deliberations. Yes, do I need to investigate?
I think that's up to the court if you want to investigate and bring in the jurors. I know that has been done in several of the cases the state cited. The court has brought in the jurors to testify. The best I can say is that's unfortunately in the discretion of the court, but it is in your power. I didn't see anything in my research that said it's a requirement. And to clarify, I don't think there's a strict bar against against statements by jurors. I think that I've set out very well that strict bar is only as to their mental processes, not as to objective misconduct. The case law is very clear. Objective misconduct is admissible.
I understand that Hawaii case law says it's discretionary. But really, when we look at State versus Chin, isn't it urging the court in that direction?
I did not brief State v. Chen for this motion, Your Honor, so I don't have that one in front of me.
Okay. Thank you, Mr. Barner. Mr. Tuck, anything else you want to?
Yes, just briefly, I'll start with that last issue about the texting. Mr. Garner says that we're suggesting anytime that happens, it's an automatic new trial. We never suggested that. We're just we're asking or that you just follow the law. And the law is what it says, right? If there's a prima facie showing and there's indicia of reliability, which we believe we've done, then that's the process. From there, the burden shifts to the state, not the court, but to the state to prove beyond a reasonable doubt that there wasn't, that this wasn't harmful. And you start with a presumption that it was. So I'm not saying every time it's automatic. I'm saying you go through this process. So we've gone through that process. And what, at the end of it, they have failed to do anything to meet that burden. And so I understand the court's questioning about the court doing further inquiry, but I would argue that that would be helping the state with their burden under the case law. So
I don't think that's what the case law is telling you.
well, the case law is saying it's the state's burden. So that's all I'm suggesting. We're here today for this hearing. They had opportunities to use their law enforcement powers to look into this if they cared enough to try or wanted to know the answer. They didn't. And so here we are, and that's all I'm suggesting is you follow the process, which is we believe a prima facie showing, Your Honor, is legally speaking a fairly low standard to reach, right? I mean, we use it more in the civil context, right, than we do in the criminal context, but it is a fairly low standard to reach. We've given the court evidence, and I don't know this argument that, well, it's anonymous, so therefore we can't. I mean, yeah, people typically don't assign their real name when they're, admitting that they were tampering with a jury. So it doesn't mean because it's anonymous we just ignore it. So I think to your question, I would submit that under law, especially in civil context, a prima facie showing is a very low burden. We've made that not only through the text itself, but the circumstantial indicia of reliability that I already articulated a couple of times. The process then shifts to the state. It's their burden to do and use their powers, that be law enforcement powers, to show these things, given that it's presumptively prejudicial. So that's what I would say about that. I'm not going to go through it all. In our reply, we distinguish the cases that he brought up today State versus Loyetta, completely different situation where there was concerns about a juror's actual like mental defects and ability to even understand like what was going on. Completely different than this case, and all the other cases that they talk about, we've distinguished and explained why in our reply. You know, we addressed in our reply this issue about polling. You know, obviously if they did something, you know, if there was an irregularity in the back, then they're gonna confirm the irregularity in the poll, so it doesn't really get to the heart of the issue. You know, this idea, when in their opposition they say you can consider 3 and 4, there was no caveat to it. That, oh, if she meant it was at the time, or if not, then you can or you cannot. That's the first time I heard of that. Their opposition is clear. You can consider statements 3 and 4 from their affidavit. I don't know if maybe somebody else wrote this or what, but whoever wrote it believed that you can consider it. And, you know, what do you think she's talking about when she says, the jury did not unanimously believe that Dr. Konig had an intent to kill his wife? Do we really think she was talking about when, like, deliberations started and not at the end? I mean, I did not believe that he had an intent to kill his wife during the incident, and I believed that he was not guilty of attempted murder. Do we really believe that she's talking about something other than what we know she's talking about, which is during the deliberations? So, I mean, that argument should not carry much weight. Again, this thing that somehow getting this right and enforcing his constitutional rights to a unanimous jury verdict is going to have a chilling effect on jurors in the future. I don't see how that would be the case. So, one second, Your Honor. You know, and again, like, I hope the court, I'm sure the court understands this. I don't know how to be more clear about it. I'm not asking you to get into the why they reached this decision, right? When the foreperson says, I did not believe he had an intent to kill, I do not believe he was not guilty. I'm not asking you to consider why she felt that way. Her deliberative process in getting to that conclusion. I'm not asking you to consider that. That's what 606 says we cannot. They wouldn't use the word processes or process if we couldn't consider the result. We poll jurors as to the result. So obviously we're allowed to ask them about the result and consider it. What would you, Your Honor, think of it this way. Think of it this way. If you polled the jury and 6 said, you know, no, I don't think he was guilty during the poll, what would you do? You would send them back to deliberate. You wouldn't be like, okay, well, we're not going to get into your mental deliberative processes and your result, and we're going to, you know, that's the secrecy of your deliberations, but we'll take the verdict and lock this guy up for the rest of his life. Of course not. So obviously the polling process demonstrates you can look at the objective end result and consider it. And I ask you to think about that. Those 2 examples. If you did a poll and it was not unanimous, what would you do? And if there was a verdict and a juror walked out and said to the camera, well, we found him guilty, but 6 of us really at the end thought he was not guilty, but whatever, you know. I have a hard time believing that Your Honor or our appellate courts would just say, hey, secrecy, we don't want to, you know, we don't want to, that's up to them. No, it's not up to them. It's not up to them as to whether they follow the law or not. And so again, you know, we're asking you to get this correct now. There is enough here to rule that way without you know, doing inquiry or whatever. They could have done that. They have investigators. If they really wanted to do that and meet their burden, they could have gone out and talked to every single juror. They didn't. And so we're asking that you grant the motion today and set the case for our second trial. Thank you.
Counsel, I understand and appreciate the arguments that you made in the application of 606B to what might have been said out into the media and what's in the moving papers that was submitted to the court. At this point in time, I am concerned about the exception to the bar that jurors can can be examined on the existence of outside influence. This is brought up by the defense in the Remmer decision. And Remmer is treated, examined, and used by the Hawaii Supreme Court on this issue. Assuming the prima facie case for outside communication has been made, right, the Supreme Court of Hawaii directs the trial court by saying where the existence of an outside influence, such as juror misconduct, is brought to the attention of the trial court, the court must ascertain the extent of the influence, and then in its sound discretion, take appropriate measures to assure a fair trial. This is State v. Chin, 135 Hawaii, 437, page 439. It's a 2015 case, and it cites Remmer v. United States in its reasoning. And it goes on to say that the outside influence need not touch directly on the guilt or innocence of the defendant to trigger the presumption of prejudice. It is enough that during the crucial period of jury deliberations, there was a private communication bearing even remotely on the trial or the jury's function in it. And I understand the argument as to who bears the burden and who needs to counter it, but here what the Supreme Court is telling this court, that the court must ascertain the extent of the influence. So the burden is on me, right? And as abhorrent as this sounds, the way I read this case is telling me that I have to do what I really don't want to do and bring in these jurors and ask whether or not they were tainted by outside influence. And as much as I don't want to do that, the case law is must. The court must ascertain the extent. So counsel, as much as you might want to rule today, I think I have to do that. Does anybody object, or do you think I'm misreading the case?
Well, our position, Your Honor, is there is enough here to grant the motion. If there's enough here to grant the motion without that inquiry, because we made a prima facie showing, and the state has not met its burden to overcome the presumptive prejudice. So there's enough here. It's not for Your Honor to go through this exercise to try and save the state's, the verdict. And I mean that respectfully. So here's what I mean. I would. There's enough here to grant it. There's enough here to grant it. If you were, you can grant it without further inquiry. I don't think you can deny it without further inquiry, but you can grant it without further inquiry. And here's the problem why it should be granted without further inquiry. Here's why it should be. We're here on, what is today, August 14th? This motion was filed on May 15th. Okay, the trial ended, I think, in April, right? So May, June, July. Well, here we are over 4 months later.
So let me put the question slightly differently. What if I disagree with defendant's interpretation of 606B and the mental processes of the jury?
Then you would still grant it as to the texting issue, following the cases that we cited.
Well, Chin requires me, right, to ascertain the extent of influence, because just because there's contact doesn't mean that it's a bad verdict.
Well, I would disagree. That goes against the cases that we cited that suggest that any outside contact is presumptively prejudicial. So we can't ignore that. We can't ignore that. So we're not starting on even footing here. We're starting on the presumption that it's prejudicial. And that's, again, State versus Furutani, 76 Hawaii 172. And the point, again, we would be ignoring that. And what do we do with the fact that the state has not met that burden and done anything?
Well, let's step back. If we take for face value Exhibit D, there's contact, but we don't know if there's influence, right? And
There was communication. And that's what the cases talk about. Communication with jurors are presumptively prejudicial. It doesn't say influence with jurors are presumptively prejudicial. And you cited, thankfully, some other cases that suggest that. We don't, it's not a harmless, hey, what'd you guys eat for lunch in the verdict room? It's presumptive, the contact, the communication itself is presumptively prejudicial. So that's what I would say about that. And I would, the other problem with what Your Honor is suggesting, which is why I'm suggesting there's enough there to just grant it now, is aside from, again, the uncomfortable nature of pulling these jurors back here 4 months later, I mean, I thought, I would suggest that it's probably unlikely that a juror is gonna come in here under oath and admit to, not following the court's rules and laws, and, yeah, I was texting with them, so, I mean, maybe they, at that point, who knows, maybe they're incriminating themselves too, so that's why there's enough here. You apply the law, which is the burden shifts to the state didn't do anything to rebut it, and grant the motion. That's at least our position, because I understand Your Honor's position, but, 4 months has gone by, number one. I don't, what if they're dishonest about it? As oftentimes they might be if they know they did something illegal or didn't follow the court's rules. I mean, are we giving them immunity to come in here and say, yeah, I was, so it's a little more complicated than I think simply saying 4 months later that'll cure everything, to come get 12 of them to come in here and say, oh no, we didn't communicate with anybody, there was no texting. So, that's kind of what I mean, right? And the state has resources. They say it's an anonymous posting, but there's a, whatever you call it, username, and I'm sure there's IP addresses and things like that the state, they had a I forget his name, but they had a forensic IT guy testify for like a day during our trial. Maybe ask him to go look into it, right? But that's their burden, is my suggestion, Your Honor. And I understand what the court is saying, but I just would ask the court to consider the problems with doing that.
Well, I fully understand the
Yeah.
problems, and that's why I'm so reluctant,
I understand.
more than reluctant.
Which is why in a situation like this, given the time that's passed, applying the procedures that's laid out, I think that's the point, is we should avoid that exercise, and unless the state on their own had did that and provided you with evidence to overcome the presumption, then the motion should be granted and we shouldn't engage in that process. That's at least our position. Thank you.
Mr. Gordon, do you want to be heard on that?
I'll repeat that I don't think defense has made their prima facie case. You can't make a prima facie case for a statement made by a person without identifying the person. It's as simple as that. You can't make a prima facie case that something was said without a witness, without any sort of follow-up, without anything else. Anybody can say anything they want on the internet, Your Honor. It is the defense's burden to make that case before any burden shifts. They did not conduct any investigation themselves. We're all in the same boat. I agree that it would be uncomfortable to bring in 12 jurors to all ask them these questions. I'm not in support of it, I guess, in that I don't think it's going to be a fun exercise for anybody. If that's court's reading of the case law is that it's necessary and required, then I won't stand in the way.
It appears that what State Justice Kent is telling, the court must ascertain the extent of the influence. And then, in its sound discretion, take appropriate measures to assure a fair trial. It's almost as if the requirement is not discretionary, it's just that the court must ascertain the extent of the influence.
But can I ask a question? And
Sure,
I mean
of
this, I really mean this. How do you then rectify that with the other cases that say the contact is presumptively prejudicial, right? Because I mean, so maybe, you know, I understand what you're saying, but there's other cases that say that, right? So the process that the way you're reading the Chin case is that no, we start equal and there's contact, and we got to get to the bottom to see if it was prejudicial or not. But there's other cases that direct us to presume that any contact is prejudicial.
Here's my other problem, Mr. Take. What if I don't think it's a real contact? I don't know. What if there was none? What if this blogger is just making it up?
Well, then that's why they have this procedure where all we need to do is make a prima facie case, and it's their job to prove otherwise. And again, like, so, I mean, anyway, I think you understand our position, but, you know, when things are worded that way, that they're, you know, presumptively prejudicial, or you know, there's a presumption, it means you err on the side that, at the start, that this was prejudicial. And you can understand why the law would develop that way. It's inherently, I mean, in this case, you know, obviously Dr. Konig is a doctor and he has private attorney, but, you know, what about, you know, indigent defendants and things like that? We're supposed to what, go hire IT guys and investigators and track all this stuff down? You know, no, that's why they situate it to where the burden is on the state to do those things once the prima facie showing is made. And so for, you know, I would suggest that it is a low bar, as low as, you know, almost as low as, you know, I mean, if there's any, you know, anyway, it's a low bar, and I think we can turn to, you know, some language in our civil case law to help with understanding that. So anyway, and again, we come back to the problem with, are we really going to call in jurors 5 months later and ask them to come in here and essentially confess to, you know, misconduct in open court without counsel, and when we already have essentially from, I know he's anonymous, but it was a written public confession that this was happening. And maybe the state should be ordered to dive in and investigate and figure out who that was. But I just, the idea, again, and I mean this out of respect for the jurors, to call them back in here 5 months later in a public setting and basically interrogate them as to if they committed, you know, potentially, you know, I mean, at the very low end, you know, misconduct, you know, on a higher end, maybe something worse than that. I just don't see how that then becomes a reliable basis for this court to then say, well, they all said nobody did it, you know. So there's enough here. That's why we follow the procedure. The state can prove otherwise, and if not, but anyway, that's just our thoughts on it. But you know.
Well, the Chin court was very clear about the language of grammar, because it discusses grammar in the opinion. And in Chin, there's contact between a witness and a juror, established contact. No, I don't know if that's necessarily true here, but in Chin, there's established contact. And in light of grammar, if there is a prima facie showing of misconduct, it says it required the court to ascertain the extent and effect of the improper influence. And there's a section of the opinion that talks about the court's duty to investigate. And the very first part of that section is when there is juror misconduct that presents a potential for substantial prejudice to a defendant's right to a fair trial, there is the rebuttable presumption of prejudice, which is what you're talking about, Mr. Otake. And the trial judge is then duty bound to further investigate the totality of circumstances surrounding the outside influence to determine its impact on juror impartiality. Again, as much as I dislike it, I think I'm handcuffed as to what this particular case requires me to do. This is a Supreme Court case. It is good law, and it is binding upon me. So as much as we all object, I think this is what's required, at least of this court. The court will contact the trial jurors in this case, have them come in, and the questioning will be conducted by the court as to, one, whether or not there was outside communication during jury deliberation. If the answer is yes, I need to probe further to ascertain the totality of circumstances of the conduct so we can determine whether or not it affected the defendant's right to an impartial jury in this case. And I understand this is the objection of both of the parties, but I think this is what is required of the court, unfortunately. So the court will make that attempt to get these jurors back. Mr. Fucking.
And again, I mean this respectfully, if that was the case, we shouldn't have set this motion 3 months after it was filed, because now this case has been heavily publicized. The jurors were told that their prohibition on reading the news or looking into it ended, and who knows what day. I mean, some of them might be watching this Zoom right now. I mean, I wouldn't doubt it, right? So, I understand what your focus on the Chin case. Again, there's the Furutani case that talks about this the state's burden. So we do object to that process just from the standpoint of the delay, the exposure, and the reality of calling jurors in here in a public setting, 4 or 5 months after their verdict, to now interrogate them about potential misconduct. And I think there's some legal issues about that. I mean, should they have counsel? Should they, I mean, do they have immunity from things like that? I just placed that all on the record, but I understand the court's ruling. Whatever the court does, we ask that we expedite it. Like when this motion was filed 3 months ago, Dr. Konig is sitting in jail. If this motion is eventually denied, we want to quickly go to sentencing. We want to appeal quickly, and we want to get back to a second trial as soon as possible, because he's sitting in jail with no bail. And so, whatever the court decides to do, we just ask that we do it as quickly as possible.
On that, Mr. Carter, anything else you want to add?
No,
We'll talk about scheduling in just a minute. I don't think we can set it next week, also. I don't think that's enough time to contact jurors. And even if we could, whether or not it gives them time to adjust their schedule. The following week I'm in trial, so I can't do it then. But I can come back during the week of August 31st. Counsel, are you available?
I am not. I start a civil trial August 31st in Judge Kimura's courtroom.
How long is that trial going to be, Mr. Otaki?
Hopefully not more than a week and a half.
What
I would
day-
say 2 weeks to be safe.
You're starting that Monday?
I believe we're starting that Monday. There was there's a moving target as to what days are off, and I think the last thing I heard is we might be going every day that week, but I'm not sure. But I would, to be safe, I think it would go into the next week for sure.
Your trial?
Correct. The one that starts on the 31st.
If I try to set it the week before, there could be a conflict with my trial. Mr. Otaki, does that prevent you from trial prep in your civil case?
I'm sorry, what was that, Your Honor?
I'm sorry.
Apologize.
If I try to set it before
The trial?
I'm in trial, but if I try to squeeze this in my trial week, I'm looking at Thursday, August 27th. I think that's ambitious. But does that still out of the question because you're doing trial prep for your civil case?
I wouldn't say it's out of the question, it's not ideal, but because we want this expedited, I'll just walk and chew gum at the same time, you know. The 25th, I cannot.
No, this will be the 27th.
27th.
The 25th, for sure, I'm picking a jury.
Got it.
Your Honor, with the 27th, I have a motion to dismiss in the afternoon, so at 1:30 p.m. Could we potentially do it in the morning?
We could.
Okay, then I should be good.
I'm sorry, I was just reminded that we actually have the hearing on the motions in limine that morning at 9 a.m. I don't believe it would go, we're limited to 5 short motions, and so the afternoon would work.
They're not available now.
Oh,
And I can't do the 28th because I already have a large evidentiary hearing.
It's the 26th, look.
The 26th, I will still be in trial.
I'm sorry, the afternoon of the 27th.
Motion to dismiss in temporary case.
We trying to move that? I don't know.
Your trial is all week, the 31st, and into the week of the 7th.
Yes, can I have 1 second?
Sure.
I think the last we heard from Judge Kimura is that there's no off days. So I suspect it would go into at least the first half of the week on the September 7th.
Should we select the?
September 7th is a holiday too, Judge.
It is. I'm talking later on in the week, the Friday. Can we do that?
The 11th?
The 11th.
We should be done by then, Your Honor.
Yeah, that's why I'm suggesting the end of the week.
That's fine with me.
Yeah.
Okay. So let's do that. Schedule further hearing, September 11th. Council 9:30 in the morning. Appreciate your indulgence. Anything else you want to take up on the record this morning?
Yes, I would ask for the opportunity to provide briefing on the process or parameters of questioning the jurors, including potentially a request to do it under seal or in camera. And if we can possibly have the opportunity to provide that briefing.
That deadline you're looking for, Mr. Otake?
Well, I would say
I want to respond.
maybe by August 28th or 21st, 1 week.
Yes, would appreciate that. Can the state respond by the 28th?
Yes, Your Honor.
Okay.
And just so I guess we have the same place to start, is the court's current intentions, the court will be the only party examining the jurors.
Right, and
Okay.
it's on the contact.
Well, and that would be what our briefing would be about. And then just the last thing I'll add, Your Honor, I mean, I understand, not to relitigate it, but the Chin case, I believe what it was standing for is you cannot deny the motion without further inquiry. But I do believe it allows you to grant it without it. So, and I think that would be an appropriate way to read Chin in conjunction with Furitani. If you're going to deny it, you need to do further inquiry. But I don't believe Chin says you can't grant it. And I think that's actually what happened in that case, is he denied the motion, and then the Supreme Court said, well, if you're going to deny it, you got to at least do some inquiry. So if you change your mind and want to grant it, we can avoid questioning the jurors, because I think it allows that to happen without questioning them. But we do appreciate the opportunity to provide additional briefing on the process, and I think we should think long and hard about how we do that, and whether it should be in camera or what. I mean, there's a lot of issues there, also, what is told to the jury about it. And I think there should be additional questions about whether they watched this hearing today, and whether they read the motions, or what they've seen since the trial. I mean, this is just a can of worms, but we'll do our best to address that in the briefing.
Thank you. Mr. Bonner, anything else you want to add?
Nothing further from me.
I guess the last thing is, I guess you're just going to reserve ruling on everything until after.
All of you brought up some very good points in addition to what was already agreed. I think we should get the full record, and then the court will make its final decision.
Understood. Thank you for your time this morning.
Likewise, counsel, thank you. Thank you for your hard work in this case. Court's adjourned.
Yeah. Probably he's got to be